Hi, it's Jessica with Leverage Legal Group. And here's a question I get all the time from founders. What's the difference between copyright infringement and a DMCA violation? First of all, let me explain what DMCA is, just in case you don't know. That's the Digital Millennial Copyright Act. So we've got the Copyright Act, and then we have the Digital Millennial Copyright Act. And what's the difference? They sound similar. They're definitely related, but they are not the same thing. And knowing the difference could save your business from serious fines, takedowns, and legal headaches. Copyright infringement is not the same as DMCA violations. Two different laws, two different risks. So let's break this down in plain English. What copyright infringement is, let's talk about that first. Copyright infringement happens when someone uses, copies, distributes, displays, performs, or including sells, especially that's the use part, somebody else's creative work without permission or without a a valid legal defense like fair use. So copyright infringement is using basically somebody else's copyrighted work without permission. That could mean copying text from a website, reposting a competitor's photo or video, or using a copyrighted song in your marketing reel. So under the US Copyright Act, which in case you're curious, is Title 17 of the US Code. Copyright infringement is a civil offense, not criminal. And it could be criminal, though, and it can be criminal if it's willful and for profit. And the penalties can be significant. So there's a thing under the Copyright Act called statutory damages. And statutory damages, what that means is that a statute has provided a set amount for potential damages for a violation of that statute. And under the Copyright Act, if you register your original work with the Copyright Office within 3 months of its first publication, you have access to statutory damages. It's a range between $750 and $30,000 per infringement, even if you didn't know it was copyrighted. So intent is not an element. The aggrieved party, the copyright owner, does not have to prove you meant to or intended to infringe on their copyright. You just have to have done it. And in that event, if they had a registered copyright within 3 months of publication of their work, they will have access to statutory damages against you. And if the infringement was willful, so if you knew or should have known that it was somebody else's content, should have known means if you did a little bit of research, you would have discovered that it was somebody else's, then your statutory fines can be up to $150,000 per infringement. So that can really add up. Plus, you may have to pay that copyright owner's attorney's fees and court costs for having gone after you. Obviously, willful infringement means much, much higher fines. That's just the civil side, okay? If the infringement was intentional and done for commercial gain, the Department of Justice can bring criminal charges, which can include fines up to $250,000 per offense and up to 5 years in prison. So copyright infringement is about the act itself, using somebody's content without the legal right to do it. Okay, so that's what copyright infringement is. So now let's talk about the DMCA, or the Digital Millennium Copyright Act. The DMCA is a separate law, and it focuses on how copyright is enforced and protected online. And it does two things. First of all, if you've probably heard about the DMCA takedown system, which gives copyright owners the right to send what are called takedown notices to platforms like YouTube, Instagram, Spotify, or various web hosts to remove infringing content quickly without going to court first. And that's why you see sometimes posts or videos disappear overnight. It's because somebody filed a DMCA takedown notice, most likely. If you ignore these notices, or if you repost the same infringing content, your account on that platform could be suspended or permanently banned. The difference is that DMCA is really about fast track takedowns and platform compliance, and the fact that repeat violations can get your account suspended. The second thing is anti-circumvention provisions. The DMCA makes it illegal to bypass or tamper with digital protection systems, ripping content from a streaming service or hacking software locks, for example. That's called a DMCA violation, and it carries with it its own penalties. So there are civil fines up to $2,500 per act of circumvention. There are also criminal penalties for willful violations, including fines of up to $500,000 and 5 years in prison for the first offense, and up to $1 million and 10 years in prison for repeat offenses. So while copyright infringement is about misusing somebody's creative work, DMCA violations are about breaking and abusing digital systems that protect that work, as well as infringing. So how do the two laws work together? They often overlap. So when you post copyrighted material without permission, that's copyright infringement. When a creator files a DMCA takedown notice to remove it, that's the enforcement process. If you ignore the takedown, or if you re-upload the same content, or if you submit a false DMCA notice to remove content that you don't actually own, you can be held liable also for a DMCA violation. Filing a false DMCA claim can also expose you to civil damages, attorney's fees, and perjury penalties under federal law. So in short, copyright infringement is about violating somebody else's ownership rights. DMCA violations violate the enforcement rules that protect those rights online. So why do founders need to care? This is why it matters. If you or your team is creating, reposting, or using digital content, whether it's social media, videos, web materials, etc., you are operating inside both systems every single day. And a single act of infringement could trigger both a copyright lawsuit and a DCMA takedown, leading to two different types of fines, lost content, and potentially a suspended business account. So remember, DMCA penalties don't just hit infringers. They can also apply if you abuse the system, like filing false, malicious takedown notices against competitors. And on the flip side, if somebody steals your content, the DMCA is your friend. And that helps you protect your rights quickly, often within hours or days, without having to file a lawsuit, at least initially. But for that to work, you have to have your copyrights registered. And that is what it gives you your takedown rights, that gives them real weight. Registration is with Copyright Office. Again, you want to have a seasoned copyright lawyer assist you with that to make sure it's done properly so that you have the protections you need to take advantage of these systems under the DMCA to protect your content. So here's the bottom line. Copyright infringement is the act of using content you don't have rights to. DMCA violations are about breaking or abusing the online systems that protect those rights. Both can lead to serious financial penalties and, for willful violations, even criminal charges. So if you're not sure about your content strategy, your legal team, or your systems, if you're not sure whether they're legally safe, let's talk. I help founders protect their brands, their creative assets, and their peace of mind. Schedule a call with me and let's make sure that your business is fully protected online and off.